India's criminal justice system has long been in need of an overhaul. The system, which dates back to the colonial era, has struggled to keep pace with the changing needs of society. Many cases drag on for years, leaving victims without justice and accused persons in legal limbo. The backlog of cases in Indian courts is staggering, with millions of cases pending at various levels. The slow pace of justice has eroded public faith in the system. Many people feel that the law favors the rich and powerful, while the poor struggle to get a fair hearing. This perception has led to a growing sense of frustration and disillusionment among the general public. The need for reform has become increasingly urgent as India seeks to establish itself as a modern, just society. In response to these challenges, the government has set up various committees to study the issue and propose reforms. Two of the most significant committees in recent years have been the Malimath Committee and the Madhav Menon Committee. These committees have made far-reaching recommendations aimed at transforming the criminal justice system in India. The recommendations of these committees cover a wide range of issues. They address everything from the rights of victims to the efficiency of the court system. The goal is to create a more responsive, efficient, and fair criminal justice system. While implementation of these reforms faces many challenges, they offer a roadmap for significant improvements in India's justice system. The Malimath Committee, headed by Justice V.S. Malimath, was formed in 2000 to suggest reforms in the criminal justice system. The committee submitted its report in 2003 with 158 recommendations. These recommendations were aimed at making the justice system more effective and victim-centric. One of the key recommendations was to change the standard of proof in criminal cases. The committee suggested moving from beyond reasonable doubt to clear and convincing evidence. This change would make it easier to secure convictions in cases where evidence is strong but not absolute. The committee argued that this would help reduce the number of acquittals due to technical reasons. Another important recommendation was to make confessions to senior police officers admissible as evidence. Currently, only confessions made to magistrates are admissible in court. The committee felt that this change would help in solving more cases and reducing the backlog in courts. However, this recommendation has been controversial, with critics arguing that it could lead to police abuse. The committee also suggested changes to the right to silence of the accused. It recommended that the court should be allowed to draw adverse inferences if the accused remains silent. This recommendation aimed to encourage accused persons to cooperate with investigations. However, it has been criticized for potentially violating the fundamental right against self-incrimination. One of the most significant aspects of the Malimath Committee's recommendations was its focus on victims' rights. The committee recognized that the existing system often neglected the needs and rights of victims. It proposed several measures to make the justice system more victim-centric. The committee recommended that victims should have the right to participate in criminal trials. This would include the right to be represented by a lawyer and to appeal against acquittals. The committee felt that this would give victims a greater sense of involvement in the justice process. It would also help ensure that their interests are properly represented in court. Another important recommendation was to introduce a system of victim compensation. The committee suggested that the state should set up a fund to compensate victims of violent crimes. This would help victims cope with the financial impact of the crime. It would also demonstrate society's commitment to supporting those who have suffered from criminal acts. The committee also recommended measures to protect victims and witnesses from intimidation. It suggested that courts should have the power to hold in-camera trials in sensitive cases. The committee also proposed witness protection programs to ensure that witnesses can testify without fear. These measures aim to encourage more victims and witnesses to come forward and participate in the justice process. Section 4. Witness Protection and Judicial Reforms. The Malimath Committee recognized the crucial role of witnesses in the justice system. It made several recommendations to protect witnesses and enhance their role in trials. The committee suggested a comprehensive witness protection program. This would include measures like police protection, relocation, and new identities for witnesses in serious cases. The committee also recommended changes to the process of recording witness statements. It suggested that witness statements should be recorded by magistrates under oath. This would make the statements more reliable and reduce the chances of witnesses turning hostile. The committee felt that this would help in securing more convictions in criminal cases. To address the issue of judicial backlog, the committee recommended increasing the number of judges. It suggested that the judge population ratio in India should be increased to 50 judges per million population. This would be a significant increase from the current ratio of about 20 judges per million. The committee felt that this increase was necessary to handle the large number of pending cases. The committee also suggested measures to improve the efficiency of courts. It recommended the use of technology to streamline court processes. This would include electronic filing of cases and video conferencing for certain hearings. The committee also suggested setting time limits for various stages of trials to prevent unnecessary delays. Section 5. Madhav Menon Committee, Enhancing Judicial Accountability. The Madhav Menon Committee, formed in 2007, focused on reforms in legal education and judicial accountability. One of its key recommendations was the establishment of a National Judicial Oversight Committee. This body would be responsible for investigating complaints against judges and ensuring judicial accountability. The committee suggested that this oversight body should have the power to investigate and take action against judges accused of misconduct. This was seen as a crucial step in maintaining public faith in the judiciary. The committee felt that judges should be accountable for their actions, just like other public servants. Another important recommendation was the establishment of an Office of Judicial Ombudsman. This office would handle complaints against the judiciary in a transparent manner. The committee felt that this would help in addressing issues of corruption and misconduct in the judiciary more effectively. The committee also recommended measures to enhance transparency in the appointment of judges. It suggested that the process of judicial appointments should be more open and subject to public scrutiny. This was seen as necessary to ensure that only the most qualified and suitable candidates are appointed as judges. Section 6. Transforming trial processes and sentencing. Both the Malamath and Madhav Menon committees made recommendations to improve trial processes. They suggested measures to reduce delays and make trials more efficient. One key recommendation was to introduce plea bargaining in certain types of cases. This would allow accused persons to plead guilty in exchange for lighter sentences, reducing the burden on courts. The committees also recommended changes to the sentencing process. They suggested that judges should have more discretion in sentencing based on the specific circumstances of each case. This would allow for more nuanced and fair sentencing rather than a one-size-fits-all approach. For heinous crimes, the committees recommended stricter penalties. They suggested that life imprisonment should mean imprisonment for the entire natural life of the convict in certain cases. This was seen as necessary to provide justice to victims of serious crimes and to act as a deterrent. The implementation of these recommendations faces many challenges. They require significant changes to existing laws and practices. There is also resistance from various quarters, including sections of the legal fraternity. However, if implemented, these reforms have the potential to transform India's criminal justice system, making it more efficient, fair and responsive to the needs of society.